Mr. Pritam Singh.
Thank you, Mr. Speaker. I think the Minister, I refer to Minister Shanmugam, has mischaracterized my speech somewhat. What I said was specific to the party position in 2019, and here there was a context. The party position, as I mentioned, was varied and divided with no consensus as to whether 377A should be repealed, and as I said, somewhat similar to Singapore society. I lifted the whip and did not fetter the voting rights of MPs. I did not say speaking rights. I did not fetter the voting rights of MPs. This is consistent with the party position. What has been the result arising from this debate? 6 for a repeal of 377A, 3 against for reasons of conscience. The party position has now been established by way of a majority in Parliament. On the Constitution, 7-4, 2 abstentions for the reasons the members mentioned. All the Workers' Party MPs, apart from Mr. Faisal Manap, who is down with COVID-19, put their personal positions on the record. And in my view, they behaved like a loyal opposition, not loyal to the PAP, but loyal to Singaporeans, knowing the position of Singaporeans outside of this House. I have 2 clarifications for the Minister, the Speaker. The first, my question pertains to an understanding of how and why the PAP chooses to lift the whip for some bills and not others. And I raise this because the Minister raised it in his closing address. DPM Wong announced that the PAP did not lift the whip for this debate because 377A is a matter of public policy. The Prime Minister in his National Day address this year said that not everyone is equally accepting of homosexuality, and there were considerable reservations within certain religious groups. Now, for the Human Organ Transplant Bill of 2009, the PAP lifted the whip so that MPs could vote based on their religious and ethical beliefs. The first generation of PAP leaders under Lee Kuan Yew did the same with the Abortion Bill of 1969, where Mr. Lee Kuan Yew himself rose to deliver a speech, but was absent when it came to voting. If I follow Minister's reasoning, would it be correct to say Mr. Lee Kuan Yew was abdicating his responsibilities? Now, there would be compelling reasons to suggest that for both these bills, public policy could have been deployed as a reason not to lift the whip, but the PAP lifted it anyway. Can the Minister please clarify the consistency or lack of consistency with regard to lifting the whip? My second question pertains to implications of the constitutional amendments for the LGBTQ+ community in the political context. With these amendments, the effect would be that the courts are not the correct forum to determine questions of housing policy and same-sex marriage, for example. At the 2011 general elections some 11 years ago, the sexual orientation of an opposition candidate came into the spotlight, with the PAP asking the Singapore Democratic Party to, I quote, come out of the closet, unquote. And the PAP statement on this issue pursued an innuendo that made an allusion to pedophilia. In view of the speeches made by PAP MPs over the last 2 days and the call for any change on the definition of marriage to be a political question, can I confirm the PAP's position with regard to LGBTQ+ candidates standing in general elections? Thank you.
Thank you, Mr. Speaker, sir. Now, Mr. Singh mentioned democracy. He said that in the pursuit of democracy, he will lift the whip. If he now says that's not so, then he can state that for the record. He said, we are more democratic, we lift the whip, and I just wanted to point out, let us just be accurate. People can speak their minds even with the whip imposed. And when Mr. Singh says the whip will not be imposed on his MPs, he is referring to voting positions. he's referring to a party position, that when he came into chambers here yesterday, the party did not have a position. That is what we are talking about. And his MP spoke on both sides. Party did not have a position. It's not a question of totaling up the numbers at the end of the day. It's a question of coming up front and saying, this is our position as a party, even though individuals have their different views and they will speak about them. That is the point I was addressing. Now, when will a whip be lifted and when will a whip not be lifted? I made it clear in this case, why is the whip being imposed? It is because it is a policy question with serious consequences for Singaporeans. If we do not repeal Section 377A, then we are saying we will not do what we have to do, and we will pass on the buck to the courts. That's an abdication of responsibility as parliamentarians. In such a situation, lifting the whip is not acceptable for the PAP because societal interests are at stake. But where it's purely matters of conscience, and you don't quite see such a significant issue for society as a whole, where the very institution of marriage and all your housing policies and your education policies and your rules on the structure and basic content of society can change overnight, and where societies get rent asunder by cultural wars. Those are the risks we are talking about. And do we duck and say, well, we don't have a position? So you're leaving it to the courts. Abortion is quite different in that it was a matter of individual conscience, at least at that point in time. I think today the issue is well settled, in Singapore at least, unlike in some other countries. But at that time, it was a matter that raised very serious personal concerns. I mean, people would know the arguments in Ireland much more recently. So I wasn't in the House at that point in time, and I don't think we should draw conclusions from the fact that one or another member was present or was not present. But I would be careful if I were Mr. Singh to bring Mr. Lee Kuan Yew into this and suggest that he somehow acted dishonorably. Now, if Mr. Singh can remind me on your second question.
It was about the LGBTQ question vis-a-vis whether they would, the PAP's position as to whether the LGBTQ community would not be victim of some personal attacks.
I think Mr. Singh mentioned pedophilia. Again, I don't recall the facts, so I can only answer in hypotheticals. I think if a pedophile was standing for elections, I'm surprised Mr. Singh would advocate that cause. Thank you, sir.
Mr. Pradham Singh.
Mr. Speaker, let me take up the last point. Before that, the point of abdication and suggesting that I'm saying Mr. Lee Kuan Yew was dishonorable. I never used those words. I think I made the point in the context of the question that I put to Minister. On the issue of pedophilia, let me share the specific statement that the PAP made, which led me to make that point. This was the statement that was released by the PAP. What is his agenda? A video has been posted on the internet showing Vincent Vijay Singha participating at a forum which discussed the promotion of the gay cause in Singapore. I don't think there's a problem with that statement. And thereafter it says, the discussion at the forum also touched on sex with boys and whether the age of consent for boys should be 14 years of age. The innuendo, I think, is clear. In the video, Mr. Vijay Singha was introduced as being from the SDP. In addition to other comments, Vijay Singha stated, I think the gay community has to rally ourselves. Perhaps one outcome of today's forum would be, for those of us who are interested, to come together to further consider how we can address the 377 issue, as well as further rights issues in relation to gays and lesbians. Now, I don't have any issue with the PAP coming up and saying, look, what is the political agenda of a candidate? But what is the relevance of that point on sex with boys? If not to cast aspersions on the candidate himself and to suggest that, did he make that point? Was this a forum where this was the only issue that was discussed? So that was intentionally included. That's my view of the statement.
Mr. Speaker, sir, I hope we don't have to go into an extended discussion on this. Mr. Singh started out the second question by saying that pedophilia was talked about. Now, let me make it clear to him. If there is a candidate who is standing for elections, whether for the PAP, and I hope the PAP will never field such a candidate, or for the Workers' Party or SDP, and if there is a suggestion of pedophilia, I will certainly speak about it. And I'm sure all right-thinking Singaporeans will speak about it and will say it is not acceptable. So I don't quite know the precise context, but as I said in my speech, offenses, sexual offenses against minors continue to remain serious offenses, and we take a very serious view. And I hope Mr. Singh is not suggesting that pedophiles stand for elections, and we do not need to talk about it. As to whether there are broader innuendos, I think let's get to the point, Mr. Singh. As the Workers' Party trooped into Parliament yesterday, there was one point, and that point is Mr. Singh, sir, as leader of the opposition, was not prepared for his party to take a position. That is what we are talking about, not about an election held in 2011. We are talking about 2022. What is our position on 377A, and whether we come here prepared to take a position or we are abdicating. I think I've made my points. We leave it to Singaporeans to judge.
Mr. Singh.
Likewise, Mr. Speaker, I think I've made my point with regard to what Minister has said, but the issue wasn't about pedophilia, and I agree with him. I don't think anybody in Singapore would be thrilled to have a pedophilia as a person who is a pedophiliac standing for elections. But the question I asked was, what is the PAP's position with regard to LGBTQ plus candidates standing in general elections? I don't think a question has been answered.
It appears to me that, as usual, Mr. Singh wants to move the goalposts and start an entirely new debate about who can and who will stand for elections. I'm not the Prime Minister or the Secretary General of the party, but my personal view is that anyone who is not a criminal and who is of good character and of sound mind and who can work for the residents ought to be able to stand for elections. In all of this, in a democracy, it also depends on how people are perceived and accepted in society. All of these are relevant considerations. One has got to look at individual candidates. But Mr. Singh started out by talking about pedophilia. I'm sure the records answered will show that. And that is why I answered, because I was shocked that he would even ask that question. Thank you.
Mr. Singh.
Indeed, Mr. Speaker, the record will show what the context was with regard to that point on pedophilia. But I accept Mr. Minister's reply to my second question. Thank you, Mr. Speaker.
Any other questions, clarifications? Ms. Hazelpour?
Thank you, Mr. Speaker. I wish to respond to Mr. Masagos' comment earlier on PSP's position. I wish to clarify that our position on wanting the definition of marriage to be determined via a national referendum instead of Parliament is not a convenient way to avoid difficult decisions. A case in point would be the fact that we do have a position on 377A, which is also a difficult one. We are aware of the government's position on what the criteria for holding a referendum is, just that we have a slightly different view on what are the issues that should go for a referendum. In this particular case, on the issue of the definition of marriage, we feel that this is an issue that is important to many Singaporeans, and there is a high level of interest from the public to have a say in this matter. And since it is an area that does not require any specialized knowledge, which makes it unsuitable for participation from members of the public, we feel that, and actually marriage, as many members have pointed out, is a matter of social norm. We feel that this is an area that is suitable for the public to participate. Thank you.
I thank the member for the clarification, but I think the most important question is not the referendum, it's what is PSP's position on the constitutional amendment. Are they for or against? And therefore, when the referendum, if held, are they for or against?
Okay, as far as the vote for the constitutional amendment is concerned, we will be voting no because of what I explained earlier, that we would like the definition of marriage to be via referendum rather than by through Parliament.
Finally, that's come out in the open. So we know that they're going to support the repeal of 73A. 377A, sorry. Repeal of 377A, but they will not support that the constitution, the amendment to the Constitution be made, which means that while now there will be no further challenges to 377A because it doesn't exist, there will now be new challenges that will be put up in court on constitutional grounds that other institutions like marriage and families, important to many Singaporeans, will now stand before the court, and then we are back to square one again. We have to reactively again come to make a decision or wait for the court to make that decision.
We will support a constitutional amendment if it says that the definition of marriage is to be determined via national referendum.
Then we'll wait for the train to crash on us.
Mr. Willem?
Thank you, Speaker. I wish to make 4 points, if I may. 3 are clarifications for the Home Affairs Minister, and 1 is a clarification on my position on the Constitution Amendment Bill. So let me go to the clarifications for Minister for Home Affairs. Okay, yesterday during his call it second reading speech, he cited many court challenges to the constitutionality of Section 377A. We are all aware of them. But I don't believe any of the ministers cited any court challenges to the heterosexual definition of marriage. So I'd like to ask the government whether there has been any court challenge to the heterosexual definition of marriage. And to that extent, would he not agree with me that his analogy of the oncoming train applies to 377A but does not quite apply to the heterosexual definition of marriage? Second clarification, earlier he mentioned that the government does not believe that their policies violate the Constitution. So I'd like to ask him, without Article 156 being enacted, is the government not confident that it can convince a court that marriage based on a heterosexual definition is based on reasonable criteria, it serves the purpose of promoting procreation within a family unit under AMLA, under Women's Charter, and therefore, the government is on much stronger footing on this, the constitutionality of the heterosexual definition of marriage compared to 377A. That's my belief anyway. The third clarification is I'd like to ask him to confirm that he accepts that the courts have a constitutional role to ensure that Parliament's laws and government actions do conform with the Constitution. I'd like his confirmation on that. And lastly, sir, my clarification. For the Constitutional Amendment Bill, I did say that I am not opposing the bill, but I'm abstaining. And the reason I'm abstaining is that I have concerned about the role of the courts as having judicial oversight over the legality of government actions and Parliament. I'm concerned that that should be protected. So I, for one, value it, and that is why I'm abstaining.
Clarify or repeat the third clarification, please. I didn't quite get that. The third clarification.
The third clarification is I'd like our Minister to confirm whether he accepts that the courts have a constitutional role to ensure that government actions as well as Parliament's laws do conform to the Constitution.
Yes. Okay, so three questions. One, whether I agree that while there is a more immediate risk on 377A, that those concerns don't quite apply to the definition, current definition of marriage. No, I don't quite agree. I think what we can see and what we need to take reference from is what has happened elsewhere. So we agree that there is a significant risk to 377A. I think there all of us agree. What is the government's concern about the current definition of marriage? You look at what's happened in India. The courts first said that their version of their 377 was not unconstitutional. And then within a few years, they said, well, it is unconstitutional. And now, earlier this year, they have said the definition of marriage should be broader than a pure heterosexual marriage. It's a similar system and similar broad common law principles. One can say and one can discern that there are different approaches that the Singapore courts take vis-a-vis the Indian courts. But I think if you were to look at it as a lawyer, legal analysis, and particularly if you are charged with a heavy responsibility to make sure that Singapore is looked after properly and that you care for Singapore, and that your concern is for the well-being of Singaporeans, then you will not take these risks. You will think them through, whether it is immediate or perhaps it is in the midterm. If you think that there is a risk, then our duty is to go out there, explain the risks, and then say how we would seek to put the laws in place to protect society, protect marriage, protect the institution of marriage and the structure of marriage, so that our society, successful as it has been, can continue to be successful, and so that the fundamental values of Singaporeans can be protected. It's not a game. You don't take chances. You don't take fine legal analysis. Fine legal analysis is necessary to identify whether there is a risk. Once you identify there is a risk, you then don't go and take chances. So if one were to ask, is the risk to the heterosexual definition of marriage less than the risk to Section 377A? The answer is yes. But that does not lead to, well, we don't have to do anything about it. If there is a risk to something as fundamental as marriage, you act, or at least this government acts. Now, second, do I not believe that the government can convince the court that marriage, that providing for a heterosexual definition of marriage, we can tell the court it's reasonable to say it should be between a man and a woman? Well, you've seen the arguments elsewhere. You've seen the social policy changes in the United Kingdom from which many of our laws come. Of course, there the laws have been changed through Parliament, but there are many countries where the laws have been changed through the courts. And I, for one, while I believe that our courts have always taken the approach, there are three great branches of the state, as I said yesterday: the courts, the judiciary, Parliament, and the executive. And the system has worked well because each has respected the sphere of the other, and our judiciary is independent. If I were asked, I would say there is a reasonably good likelihood that we will be able to persuade the court today that there is a basis for making a distinction between same-sex marriages and heterosexual marriages, and that the current definition of marriage in the Women's Charter should be maintained. But if I were asked a different question, is there a risk that it could be struck out? I think it would be either a stupid lawyer or a foolish lawyer who will say there is no risk. And if you accept that there is a risk, then what do you do? What do we do as parliamentarians? I think the answer is clear. Third, do I accept that the courts have a constitutional role? Of course I accept that. But I think if the question goes towards why do we then say that the courts should not look at the definition of marriage, I think I've given a very extensive answer. What should count as marriage should be decided here. The courts can only make binary decisions. We should discuss it, we should decide it, and we should take into account what society is ready for and what society needs and what strengthens society. And even if we take a view which is different from the majority view, then it's our duty to go and convince society as to why we are taking that view. We can do all of those things. The courts cannot do those things. That is why we have decided there is this risk that the definition of marriage could be challenged. And we have decided that's a matter for Parliament. We are not providing for a supermajority, so any elected government, by a simple majority, can decide on what a marriage ought to be like. That is democracy. That's how democracy ought to work. And no court can do what we did yesterday and today, which is to consider repealing 377A, but at the same time, strengthening the institution of marriage and explaining the reasons, having it fully discussed, going out to the public and explaining. That is what's necessary, and that we believe that a future discussion would require these sorts of discussions, and it may require changes to more than one piece of legislation. How does the court do that? They will decide on the question presented to them and strike out if they think it should be struck out. Where does that leave society? So this is not a case of, oh, are we avoiding the supervisory jurisdiction of the courts? It's been explained. And I believe majority of Singaporeans, the overwhelming majority of Singaporeans, support us on this constitutional amendment.